morning. May it please the court. I'm proud to represent Heart of Adoptions in this matter. There are multiple fundamental flaws with appellant's position from a substantive perspective. But I want to first emphasize that most of their arguments were not raised below, find absolutely no support in the record, and are actually a recharacterization of what occurred below. I urge you to look at the docket sheet that was filed in this case so that you can see what was filed with the trial court and when it was filed. The paternity action was not part of our case. That was filed in a different county. It was not served upon nor noticed to Heart of Adoptions. It was not noticed to the judge. The notice of related action that
Would you be a party to the paternity action?
We certainly would be an indispensable party because the mother had signed an irrevocable relinquishment of her parental rights to Heart of Adoptions. So as the legal custodian of the child under 63054, I would submit that we would be an indispensable party. But at a minimum, their notice of related action filed in the paternity case should have notified our judge, because this case is not about the paternity case. This case is about the termination of parental rights action, should have noticed our judge about the pendency of that case. But their certificate of service was defective and did not follow the rules of judicial administration.
Just so you understand that when the paternity action was filed, the only document filed in Hillsborough County the notice of intended adoption plan?
No, that wasn't the only document filed. The petition to terminate parental rights was also filed.
The petition to terminate was filed before the 742 proceeding? I thought it was the other way around for some reason.
The 742 proceeding was filed, I believe, a day before the petition to terminate parental rights. But this case is about the notice of intended adoption plan that was filed months before the paternity action and a hearing scheduled to determine whether or not under 63062 this birth father's consent was required to the adoption. And I would submit to you that he is relying on documents and pleadings that were not part of the record below, and he cannot meet his burden to prove error, much less reversible error. We believe that this case is very clear and straightforward, and it's predicated on the appellant's undisputed failure to follow two of the three prerequisites that are set out here in 63062. These are separate and independent, so if he flunks sub 2 or sub 3, you support the trial court's decision. And to answer your question, Judge Altenburg, the trial court held a full and fair evidentiary hearing in this case. That is reflected right in the introductory paragraph of the order that's appealed. He took evidence.
Can we tell at all how many witnesses were called or anything like that?
The trial court's order reflects that he took testimony from the birth mother and the birth father. And I was present at that hearing, and that is an accurate recitation. There were no other witnesses called.
If we needed to get a summary of the evidence, then we probably could still do that.
Well, they certainly didn't do that in invoking the rules of appellate procedure to recreate that evidence, but the court made specific factual findings in that order that are supported by the law. And the fundamental and glaring defect with the appellant's position is his failure to accept the consequences of his refusal to pay a fair and reasonable amount of support for medical and living expenses to the birth mother during her pregnancy and to the child subsequent to birth.
Well, that is required. Up to the time of the evidentiary hearing, what does the record establish that amount to be?
The record established that there was a 11-month period in question, and for 10 of those 11 months, he paid nothing. It isn't a question about the agency dictating how much he should pay. He paid nothing.
What is a putative father supposed to do as far as paying? What does the case law say?
The case law, starting with the Supreme Court in the 80s in Ray Doe, a fair and reasonable amount of support. When you pay nothing, You can't argue that you paid a fair and reasonable amount of support.
Well, his
And the-
position on that, of course, is he was only given one bill and he paid half that bill and he otherwise never was given any bills. So how can he pay if he doesn't really know what he's supposed to pay?
Well, the Notice of Intended Adoption Plan outlined all of the birth mother's living expenses. It also outlined her medical expenses. It itemized living expenses. He never paid any living expenses. The trial,
Plan in the record?
yes, sir.
Okay.
Yes, sir. And the trial court found that he never paid any living expenses. He never disputed that. He admitted that. The only thing he paid, and the trial court found this to be a nominal contribution, was $150 towards thousands and thousands and thousands of dollars in medical bills. There is not one case in our state, and there is nothing in that statute that requires a birth mother to ask for support, that requires a birth mother to outline her expenses, although that was done here, and certainly nothing that requires her to provide bills or receipts. This is a red herring. She sent him the contract that she signed with her OB.
Cut to the chase on this issue. To the extent that he thought he was acting reasonably, that would have been the subject of the evidentiary hearing for which we have no transcript.
Exactly, but you have the court's factual findings that are supported under 63-062 and the abject lack of any support for 11 months to this birth mother. The whole predicate of the statute is so that the courts and adoption agencies, my client, can determine if these children are legally free for adoption at birth, and we are not faced with a baby Sam or a baby Richard case where we're taking children out of homes screaming from the only parents that they've ever known years and years down the road. Doe, EAW, two seminal Florida Supreme Court cases in this area did not require the birth mother outline her expenses or provide any bills or receipts, and both of those birth fathers were foreclosed from vetoing her adoption decision. So on this basis alone, the factual findings of the trial court that I would submit that we cannot look behind and that were undisputed support the findings in this case under 63-062-23.
Address, if you would, the affidavit and the venue argument, because I think that's an interesting argument that I've not seen before.
Well, interestingly, Your Honor, we hadn't seen it before either because it was not raised in the trial court. They did not raise that issue below, and so it is waived. They did not raise it, and they didn't get an argument or any. The trial court. This is.
When would they have raised it, though? If they file the motion to transfer venue, and if they believe that the rules do not require them to file anything else, the affidavit, any other documents till the motion to transfer venue is ruled on, when would they have raised the issue?
They would have raised it at the hearing on the motion to determine whether the birth father's consent was required. This statute, persons required to consent to adoption, 63-062, is the beginning and end of what happened in the trial court below. And when we're in our motion telling this birth father, you need to file an affidavit of inquiry and an affidavit of responsibility, and he doesn't do it. He should have argued at this hearing that he didn't have to do it because he was told. This isn't a birth father that didn't have opportunity. He knew about the pregnancy month 1. He knew about the adoption plan in the 2nd trimester. In August, he was sent an adoption disclosure that outlined to him the fatal consequences of not filing an affidavit of responsibility within 30 days of being served with the notice of intended adoption plan. In November, this is all pre-birth, in November he sent the adoption disclosure again, and then he's personally served with the notice of intended adoption plan. Read it. It tells him very specifically what he needs to do to convert an inchoate opportunity. That's all he has. Lair, United States Supreme Court, Florida Supreme Court.
The argument is that when the TPR petition is filed, that resurrects the opportunity to file an affidavit. And is there any case that outright says no? I mean, I appreciate your argument, and I understand what the statute says and what the notice says. But again, it's a different argument. So is there anything that has addressed that?
No, but I don't think you can justify that argument with any reading of Heart of Adoptions versus JA, because they squarely come out and say that the failure to file an affidavit of responsibility within 30 days of service of the Notice of Intended Adoption Plan is a death knell and means that he has no rights to the child. And that is the leading case under 63062, and of course is a directive from the Florida Supreme Court. So also the KH case that is in our materials, which is a recent decision out of the Fourth, very squarely determines that the failure to file an affidavit of responsibility in response to the Notice of Intended Adoption Plan means that he has no rights to the child. And the subsequent...
The statute also provides in one of the subparagraphs that an unmarried biological father who does not comply with each of the conditions provided in this subsection is deemed to have waived and surrendered any rights. And I think one of your arguments was if he didn't file it within 30 days, the petition for termination is almost irrelevant to him.
It is, Your Honor, exactly. He doesn't have parental rights. He had an opportunity to create parental rights and become a parent, but he didn't. He didn't because he didn't support, and he didn't because he didn't timely file the affidavit of responsibility. As Justice Morris pointed out, this is a substantive requirement. This isn't a pleading requirement. It's substantive. Heart of Adoptions versus JA, Florida Supreme Court, it's substantive. It's what gives you rights, because before that, you only have an inchoate opportunity. And so those rights don't mature. They don't give you a seat at the table down the road.
There was also the argument, and I'm not finding it in the statute, and I think it's in there somewhere, the DNA testing. Isn't there something within this statute that allows a putative biological father to seek DNA testing to confirm it?
Yes, sir, in 63054, but let me make it clear, there was no request for DNA testing in our case. And also, there was no dispute about paternity.
But once the notice was sent out, the original notice of intended adoption, is that the time, is it at that time that the DNA test can be requested? And if so, how does that correlate to the 30-day period to file the affidavit? Do you file the affidavit saying, well, if it turns out that I am the father, this is my intention?
Certainly, that you accept responsibility for the child, you agree to a court order of child support, and you agree to pay the birth mother's living and medical expenses during the pregnancy. That's something he never did.
Do you do that if you have some concern that, well, maybe I'm not the biological father? How does the timing work as far as a DNA test under this section, this statute, and the affidavit?
As soon as the Notice of Intended Adoption Plan is filed, he can file a motion for DNA testing. He can also file his affidavit of responsibility. If DNA testing establishes I'm the father, I'm willing to...
It could be a conditional affidavit.
Certainly, because we only impose those requirements on people that not only are biological fathers, but are also parents. And I think it's key to understand the statute. It's not biology that determines whether you have rights. The United States Supreme Court in Lair told us biology is not enough. It's biology plus. The statute says biology is not enough. It's not whether or not you're a father, it's whether or not you're a parent. And you can't become a parent unless you comply with 63062, i.e. pay support and timely file the affidavit of responsibility. I can't emphasize enough that this was a factual finding made by the judge after a full and fair evidentiary hearing. He paid nothing for 11 months. He has paid nothing for 11 months.
In theory, and this may not be good practice, but in theory, when the separate paternity action is filed, could the father have filed the required affidavit and said, we have asked for DNA testing in this other case that we have filed, and therefore we're submitting an affidavit that if in fact we're proven to be the biological father, I'm proven to be the biological father, yes, I will accept all these rights?
In theory, I suspect he could have done that, but we didn't know about the paternity case.
Even if it could be done in theory, your position is, but it wasn't done.
And why wouldn't he have filed a request for DNA testing in this case? So our judge would have had that before him, so we would have known that he was challenging his paternity. He never challenged paternity in this case. And he had the duties...
Time frame in this statute by which you have to ask for DNA testing?
No, sir. It can ask for it at any time, and the court can order it at any time if it's aware that there's an issue about paternity. But I do want to address the fact that he's argued that a court order of child support is required. There's no case in our state that has ever held that an order of child support is required in order to invoke the provisions of subsection 3. There was no court order of child support in JCJ. Your decision just a couple years ago, which said the affidavit of responsibility and the failure to file it is a death knell. There was no court order in Doe. There was no court order in EAW. There's been no court orders in any of the adoption cases that I'm aware of since 2002 and beyond that address that issue. The Notice of Intended Adoption Plan outlines his responsibilities. If you didn't want to read it in the statute and he had a lawyer, the Notice of Intended Adoption Plan speaks in no unmistakable terms as it relates to that. The last thing that I want to mention is his brief relies heavily on letters that were exchanged between the lawyers during the course of this litigation. Those letters were never filed with the court before the court made its ruling. Those letters were never introduced into evidence. And those letters, on their best day, are nothing more than lip service to his obligations to pay support. And right there, our legislator has codified that well-known adage that actions speak louder than words. And it's not what a birth father says he wants to do, but what he does that determines the outcome of these cases. And he needed to step up to the plate and pay support in order to have a seat at the table. He needed to file an affidavit of responsibility timely in order to have a seat at the table. He did neither of those, and we respectfully request that you uphold the decision, the factual evidentiary decision of this very learned trial judge. Thank you.